Opening speeches are made in a variety of courts and tribunals by lawyers across the country on a daily basis. There is, however, a very different and very targeted approach which I suggest should be adopted in the Magistrates' Court. For example, if we look at the difference between the Magistrates' Court and the County Court, we'll see that they're different types of tribunal. And by that I mean that in the County Court it's judge-led. The judge, whilst he is a trier of fact and law, comes at matters from a legal background. In the Magistrates' Court we're dealing with primarily, and I stress primarily, lay people. Those lay people are not legally qualified, and perhaps most importantly, whilst they hear a number of cases each and every year, they will approach matters in the courtroom different than someone who has been trained with a legal background. The main difference I suggest between the Magistrates' Court and other professional tribunals is this. The professional tribunal will have, at least in theory, have read the background to the issue before it and will have an understanding from those papers of the issues in the case and the potential evidence to be heard. So a opening speech in a county court is going to be formulated very differently to one in the Magistrates' Court. Typically in the Magistrates' Court there is only one opening speech. The defence typically make the only closing speech. Crucially, I suggest the magistrates, when they walk into court, with their lack of knowledge about the facts and the background to the case, do need to be signposted as to what the dispute is about and why that defendant and those witnesses are coming to their Magistrates' Court on that day. I suggest that you should outline the essential facts of the case. I suggest that you should fill in any background which will help persuade the court ultimately towards consideration of the points to prove. What you shouldn't be trying to do is try to win the case in the opening speech. Winning the case will come from the witnesses and their evidence. You don't need to persuade in an opening speech in the Magistrates' Court, and that again makes it distinct from opening speeches in other court and other tribunals. You are, if you like, a tour guide. At all times it's essential that you recall your purpose as a tour guide so that you can point out to the magistrates where to listen closely and where to focus the attention in terms of what you're seeking to prove. You're going to tell the court what happened, where, why, and perhaps how. I suggest there are some good practice criteria that you must follow. You should prepare from the originals. If you're opening for the Crown Prosecution Service, you will be provided with a summary of the case prepared by the police and a set of witness statements. If you're opening the case for any other prosecution agency, you will still have the statements, but you may not necessarily have the case summary. For example, in my experience, DWP prosecutions, not all of them come with a case summary. It may be helpful for you to prepare one going forward, but it may simply be that you prepare from the originals. I suggest in each and every case you should go to the originals in any event, because the police are not legally qualified. They do not have an understanding of the rules of evidence, the admissibility points that can arise, and in order to ensure that you consider those points, you shouldn't rely upon any summaries or any preparation undertaken by others. You need to prepare your opening thoroughly. That's simply said, but what does it mean? It means that it must be planned and it must be structured, because your opening should take no more than 1 to 2 minutes. Keep your case simple and keep your case low key, I suggest, and your preparation should reflect that. You're going to avoid emotive language. You're going to only make essential comments. And you don't want to try and replace the witnesses or indeed give your opinion. You equally should not be advancing anything within your opening speech which is disputed or perhaps unsupported. If you're not sure, check with your opponent whether or not they're happy for you to open on a particular point. Particular caution must apply where something is perhaps going to be subject to an admissibility test later on in the hearing.